6, and starting with why it's important to first retain an attorney's assistance to help you with a loan modification. We, as your law firm, we will negotiate very aggressively with your lender. We're the ones that don't take no for an answer when they try and say that you're not approved. We will say why, we will fix it, and we will resubmit you, and we will do it over and over and over again until we get a qualified package that gets you a loan modification. We don't let the lenders walk all over us when they try and say, oh, we didn't get these documents. We're the ones saying, check your file again. I sent it on this day at this time, spoke with so-and-so to let you know that your documents were submitted and your file should be, in review, in active review for a loan modification. We have established relationships with a lot of the negotiators at lenders, so we directly contact people that we've worked with before in the past. So we're able to have a personal relationship with people who are the ones reviewing your file directly to approve you for a loan modification. And the most important one is the investors are constantly changing their guidelines of what's required for a loan modification, and we are constantly on top of all of these changes, all of these guidelines. Whenever investors change the requirements for a loan modification, we learn them, we're on top of them, we calibrate and we adapt and change your package so it can qualify. So we submit a package that we feel confident behind, stand behind to get you approved for a modification. Come on in.
Just sign it right there.
So go ahead and the next slide. So we're going to go over basically the basics of when you become a client with us. As soon as you finish dealing with Joy, your file will get assigned to either myself or Nadia. The first thing we do is we review all of the entire package of the file. We look at all of the notes, every single conversation you have had with anybody at the law firm, so we know all of your history, your hardship, why you want a loan modification, so we know the majority of the information before we even contact you. We review all of the documents that we've requested from you guys to basically see what else is going to be needed. We research the property, we look at the value, the appreciation or depreciation rate, where you're located. We basically get as much information on your home as we possibly can, and we're really good at it. Then we do an introduction client call. We call you. We go over what your hardship is, why you need a loan modification, the last time you made a mortgage payment, what a good payment for you is that you would like to get for a modification. Then we discuss your income, your expenses, and any missing documents that we're going to need to process your package and submission as quickly as possible. The next thing we do is we call your lender. We do an introduction lender call. This is when we get the details of your loan, the specifics. We find out what the current interest rate is, what your current monthly mortgage payment's at, what the original payment was, if you've ever been in review for a modification before. If you were denied in the past, we like to know why you were denied in the past so we can try and fix it, maybe try and make sure that we don't go encounter that problem again in the future. The next thing we do is we run an NPV test. This is called the net present value test. We use the majority of the information that we get from that introduction lender call to run a test that the lenders are going to run themselves. We run it first so we know what they're going to see when they run it. The purpose of this net present value test is for the lender to see if it's worth giving you a loan modification, if they benefit more for foreclosing on your property or giving you a loan modification, what benefits them. So the factors that go into it are the original principal balance of the loan, the original interest rate, the current interest rate, how many months you're behind on your loan, what the property is worth, how much your monthly income is. There's a lot of information that goes into the test. It's a very in-depth test that we actually run before we even send your package out to the lender. The next thing you do is run a mortgage payment calculator and create your monthly budget. This is to be able to see how much of a mortgage payment we can get you, how much we can lower it by, what is a good comfortable payment for you. We compare your income and your expenses to see what your debt to income ratio is, and we basically create that budget and we play with your numbers and your figures to get you in a qualified bubble that we know that the lenders are looking for, so we can create that package that best fits for whatever submission we're going to try and get you in for. Then we call your lender and we submit verbal financials over the phone. This is what gets you pre-qualified for a loan modification. As soon as we do that submission, that verbal submission, then they say, okay, send us a package in. Then we send them a 50-page, 80-page, 110-page package of all of these documents, of all of these worksheets that we create. And that's when the negotiations start. That's when we start going back and forth with your lender to try and get you into a loan modification. Now, the definition of a loan modification, it's basically changing the terms of your loan, requesting assistance for you because the original contract of your loan is something that you can't afford anymore. And we basically want to go back and say, let's lower the interest rate, let's, try and get them a principal balance reduction. They need assistance, and due to some type of hardship. Some of the hardships that your lenders like to see for you to qualify for assistance would be a loss of job or a decrease in income due to hours going down or furlough days, an increase in expenses, especially due to like medical bills and medical expenses. Even a divorce is a hardship because that's a decrease in household income from the separation of the two parties. And if you're facing foreclosure, all of these things are ways to tell your lender, we need help, we need assistance, we need a modification. These are some of the programs that are out. These are just a few of them. There's a lot of others, but these are the main ones that we like to get you in review for, and these are the most popular ones and the ones that we've seen a high success rate with our clients to get them assistance and get them loan modifications. And so me and Nadia are going to cover these, some of these programs. The first one is the Home Affordable Refinance Program. If you can see that we have the slide, so we give you all of the details in there in front of you. This is a program that's for borrowers who are current on their mortgage payments. Basically, you haven't fallen behind, you still need assistance. There are a couple of eligibility requirements. The mortgage must be owned or guaranteed by Freddie Mac or Fannie Mae. The mortgage must have been sold to Fannie Mae or Freddie Mac on or before May 31st of 2009. The mortgage cannot have been refinanced under HARP, the program that we're going for previously, unless it is a Fannie Mae loan. It was refinanced by HARP from March to May of 2009. And the current loan to value ratio must be greater than 80%. Basically, you have to be underwater. And the borrower must be current on the mortgage payments at the time of the refinance with a good payment history in the past 12 months. So even if you are current, you still have to have had a good current payment history for the past 12 months. The current floor rate for this program is 4% as of right now. The next one is the Home Affordable Modification Program. This is one that we've seen the most success rate with our clients that we have right now. This is the government program, and this is one that a lot of people are very familiar with right now. And the purpose for this one is if you are not unemployed, you have to be employed and have to have income, steady job income from this one. And the purpose of this is to lower your monthly mortgage payment to about approximately 31% of your gross income, your gross household income. And some of the requirements to be eligible for the Home Affordable Modification Program is you have to occupy the house and it has to be your primary residence. You attained your mortgage on or before January 1st of 2009. You have a mortgage payment that is more than 31% of your monthly gross pre-tax income, because we're trying to get you down to 31%. You owe up to $729,750 on your loan, on your home. You have a financial hardship and are either delinquent and are in damage of failure, falling behind. So this is the hardship where you tell them that you had a loss of income, decrease in hours at work. You have sufficient documents to support the hardship. This is why we ask you for the pages and pages and pages of documents, because your lender is going to want detailed specifics of your hardship to prove why you need assistance. And then you must have not have been convicted within the last 10 years of a felony, larceny, theft, fraud, forgery, money laundering. I'm sure you guys are all great people here, so we don't have to worry about that. Now, just a quick example before we move on to the next one. Actually, I just got the documents today of a client that was just approved for the Home Affordable Modification Program. It starts with a trial period where they give you 3 months, basically trying to see, are you sure they're good faith 3-month payments to show, I'm serious, I'm going to make these payments, I'm willing to work with you because I want to keep my home. And I just got a client modified for a Making Homes Affordable program, where we dropped her payments from $2,976 down to $1,755. We decreased her monthly mortgage payment by $1,200 approximately. And her interest rate, when we got her interest rate was already at 3%. So some people think, I already have a really low interest rate, can I get help, can I get assistance? We did it, we knocked it down from 3% down to 2%. And she was able to get a lot of help, so we decreased her payments by $1,200, and that actually just happened in the past week. So that's with the Home Affordable Modification Program. The next is the Home Affordable Unemployment Program. So this is for those clients who are unemployed. It's a different program, it's a different section that you go and review for, but it basically is the same as the Home Affordable Modification Program, and it's just to get you qualified. The main thing that your lender wants to see with this program is that you are going to have steady income. Even though you are unemployed, that you're receiving unemployment. And so they want to see that you are eligible for unemployment benefits and that you're going to be receiving unemployment benefits for at least a year. They like to see that, to know if we give you a modification, will you be able to pay that new mortgage while you look for a new job. So it's basically exactly the same, even the requirements as the one before. The next slide. This is the 2MP program. This is a modification that modifies your second, if you have a second mortgage on your home. In order to qualify for this one, you have to have had your first loan modified under the HAMP program. And once you complete 3 of those trial payments that I explained, your lender sees that, okay, they made the payments, they're serious about getting a modification and keeping their home. They're able to make payments on the new loan modification. So now we can give them a modification on their second. I actually was able to get a modification for both the first and the second with Wells Fargo just recently, where they saw the client was making their payments and they went ahead and gave them the modification on the second for the 2MP program, and that was with the entire submission that we had submitted all in once. So those are the first set of programs. I know that Nadia is going to continue and keep talking about some more.
Here. Okay. Now this is the principal reduction alternative. This applies to homeowners whose current home value is significantly less than what they owe on the loan. Some eligibility requirements, it cannot be owned by Fannie Mae or Freddie Mac. You have to have this as your primary residence. Of course, you have to have obtained the mortgage before January 1st of 2009. And there's a couple more available here. But also to be noted is that when they offer this program, it can be offered once you were initially approved for modification, or they can offer it over a step process, over 3 years. For example, I actually just got a loan modified with Wells Fargo, and they were approved for the modification, and there was a clause that they were approved for this PRA program. However, he would have had to make 3 years of mortgage payments on time in order to get that principal reduction reduced. So he was offered $59,000. So for every year in that 3-year period that he made his payments on time, 1/3 of that amount has gotten reduced. And then the FHA short refinance. It's the same concept as a regular refinance. However, it applies to those mortgages that are FHA insured. So a couple eligibility requirements. It cannot be owned by Fannie Mae, Freddie Mac, FHA, VA, or USDA. You have to be current on your payments for most refinancing anyway. Important thing to note about this program is that lenders are not required to offer this to borrowers, so it's strictly voluntary, their participation in this program, so it's definitely something to keep into account. And then before I move on to our last slide regarding the modification programs available, a lot of homeowners are unaware that most servicers do offer in-house modifications. So let's say you do not qualify for HAMP under their guidelines, they will review you for an in-house modification. Often can better benefit certain borrowers because they use different criteria. So they'll use the net income rather than the gross income, and I know many borrowers are very upset when HAMP program uses gross income because it's not a realistic intake of what a person takes home at the end of the day. So it's definitely something to consider, and when the bank does review the file for modification, they'll do what they call a waterfall method. So they'll review you first for the HAMP program, and for whatever reason you don't qualify for that program, they will definitely consider you for this program. And then finally, this is not a modification. This is for those who realize, you know what, I really just can't afford the mortgage anymore. Even if I'm offered a modification, I just can't keep it up. I need to get out of it, but I want to have a smooth transition and on good terms with the bank. So the HAFA program will offer you 2 options for getting out of your mortgage: a short sale and a deed in lieu of foreclosure. A deed in lieu of foreclosure is a little less common, but definitely available. And it signifies a lender accepting for you to give back the title. In other words, transferring ownership back to the bank. So at that point, you're satisfying the loan that's in default, and you're avoiding any kind of foreclosure proceedings. You also have the short sale program, and at that point, the bank is allowing you to sell the home at an amount that falls short of what you owe. And the bank does prefer this route rather than a foreclosure proceedings because it does cost less money for them. And it's the same kind of option as being reviewed for a modification, except you're reviewed in a short sale department. And there's just a little bit of different characteristics in the sense you have to show a listing agreement, but the bank does work with you throughout this entire process to get the best possible offer on the short sale. And here I gave a couple benefits for a short sale versus a foreclosure. I know many people just want to give up and say, I don't want to have to deal with another short sale review or anything of that matter. It does go rather quickly, and of course it affects your credit score a lot less than it would a foreclosure. It remains a less amount of time on your credit than a foreclosure would, and of course it better benefits the bank, so they're more willing to work with you pursuing a short sale. Okay, now the possible modification outcomes. As you know, a modification process can take a few months. And at that time, we're needing your cooperation to supply documents, and you guys are all stressed, and we're negotiating aggressively on your end, and then comes the outcome. The most successful outcome, the one that we aim to get, is a trial modification. So before they can offer you that permanent modification and give that stamp of approval, they want to set you up on a trial modification. I know Michelle brushed on it a little bit. It's been a few months since you made your mortgage payment, so the bank wants to ensure that you can make these payments and make them on time. After you successfully completed the 3-month trial plan payment, which of course will be a lot lower than your original mortgage payment, then we will go back in and submit the file and renegotiate for a permanent modification. That can take about a couple months after you successfully completed the trial plan, and at that point we do advise you to keep making those trial plan payments until the final decision has been reached. And then once everything is all said and done and you guys have done your part and we have done ours, the permanent modification is offered. Now, if that's not the case, and for whatever reason you guys get that dreaded denial letter in the mail, then before throwing in the towel and giving up, we need to figure out what was the reason for the denial. Was it too much income, lack of income, investor guidelines, not sending in documents? At that point, we rework the file, whether it's tweaking a number here or there, we rework it and we resubmit it. And the important thing to know is that, and exactly that's why you do come to a third party rather than having to deal with it on your own, because it is stressful to have to deal with the whole entire process again.
A side note on that with Nadia, I just got a client a loan modification recently. We had to submit him 5 times. We had to resubmit him 5 times before he got a successful loan modification that decreased his rate immensely. He's extremely happy with it, but it did take trial and error figuring out how to tweak his income, how to tweak the expenses, and we just keep working and reworking it. We don't take no for an answer, but we did successfully get him a permanent loan modification after 5 attempts.
And then, let's say you get a denial, but there's a foreclosure sale date around the corner. Usually the bank will only allow you to resubmit a file as long as it's more than 7 days before the sale date. But let's say you get the denial letter a little bit, maybe say 2-3 days before the sale date. At that point, we need to figure out the options if you do want to save the home. One option is possibly reinstating the loan. Of course, that's sometimes unrealistic for certain borrowers, depending on how many months you are behind. But reinstating just simply involves paying back everything that you owe, including the attorney fees and costs and kind of late fees, and fully reinstating your loan, meaning you're bringing yourself back current and in good standing with the bank. Then they could possibly put you on a repayment plan. Of course, that's sometimes not a viable option for some borrowers because it does double your payment, because they want you to pay back what you owe over a 6 to 9 month period. So if the clients can afford it, of course, definitely that's the option to go. But of course, if they're facing a hardship, it's not very realistic to follow that route. Finally, which I know I brushed on before, is a short sale. That's of course if you don't want to, you don't want to modify the loan. I mean, they don't accept to modify the loan. You don't want to file for those other routes, so you decide to do a short sale, and at that point, you're at least in good standing with the lender, and they will postpone the sale date while they review your file for the short sale. And then finally, the bankruptcy route, and I know Ryan will brush on it in a little bit, but that definitely, if you do file that Chapter 13, which he will explain in more detail, that will automatically protect your home. Of course, you have to keep up with the terms of the bankruptcy, but as long as you file it before the time of the sale, your home is protected. And then one more thing before I give the floor to Ryan. I know sometimes people are a little bit confused as to how the foreclosure timeline works out. So just to give you guys an idea, within the first 2 months of missing the payments, you'll start receiving that notice of default. At that point, it's the bank's warning to let you know, listen, we're going to give you 90 days to cure your defaults and get you back on track. If at that point you don't do anything, or at least give a good faith payment to show that you're interested in keeping your home, we'll issue a notice of sale. that point, they will give you a date, usually within 21 to 25 days as listed. And at that point, again, if no action is taken on your part, they can proceed with the sale. It can go to auction at that point. Either a third party can buy it or the bank can take it back. So if ever you're facing a hardship, you want to make sure that you avoid this part of the screen and try to deal with, your hardship and getting back on track with the bank before reaching that point.
The important thing to remember about the foreclosure timeline is to let you know that we have time. When you first miss that first payment, second payment, third payment, and you start freaking out and wondering if you're going to lose your home, this is to show you that you can breathe, it's okay. We have minimum 6 months to help you and to get you a loan modification. And right now the process has been moving a little quicker. We have been seeing modifications coming in as short as 3-4 months. So even if you do go into default after about 3 months behind, you still have maybe 6 months to try and work with us and to get you some assistance before even having to worry about a trustee sale date.
Yeah, and just one more clause also I wanted to throw in there before I give the floor away. If you do get a notice of sale and your file is active and under review, we can request to postpone the sale date. I know many borrowers are always worried about when a file is in review and they get that notice of sale on their door. We can definitely work with the bank until they reach that final decision before they proceed with the foreclosure. So just to keep that in mind as well.
I have a question before you turn it over. You mentioned if there's a sale date, and let's say your file gets denied days before your sale, you might file for bankruptcy to stall the sale. Bankruptcy provides that protection. My question is, at that point, is loan modification off the table, or after the bankruptcy, can we reapply for a loan modification?
You can definitely reapply for a loan modification, and in fact, it's a little bit easier. First of all, you're dealing with a separate department. You're dealing with the bankruptcy department, which works a lot more efficiently and review your file in a lot more detail. So let's say you do have that notice of sale, you do decide to file for bankruptcy. As soon as that bankruptcy has been filed, I can take that case number, I can advise the lender and say, listen, we still want to pursue a loan modification. Here's our package. Please consider it, and they'll keep everything into account. So it's definitely an option. Don't think that a loan modification is not available once that bankruptcy has been filed.
As an example of how quickly the bankruptcy can help the loan modification move, we had a client at the end of December who had a trustee's sale date on her property. She got denied for a loan modification just days before the trustee's sale. So we filed a Chapter 13 bankruptcy for her. She was approved for a modification within 1 week after filing that bankruptcy. So all I had to do was call over to the bankruptcy department, have her file moved over to the bankruptcy department, say, let's go, let's get her modification, and she was approved within 1 week after the bankruptcy was filed.
Now, it's not always going to be that easy, but one thing that we noticed with that particular client is that she had tried to do a loan modification 5, 6, 7, 8 times. She was behind by more than 2 years on her mortgage, a couple $100,000 in arrears, and they knocked off, I don't know what percentage of her payment, I'd say like 30 or 40%.
We decreased her payment by about 40%.
Yeah.
What are they filing bankruptcy on? Their overall, what they owe out, but just on the house? What if you don't have any bills?
Those are awesome, a lot of awesome questions that Ryan, our bankruptcy attorney, is actually going to be covering them. Oh, no, don't worry about it. Awesome questions, yeah. And so we're going to let Ryan Stubbe take the floor. He's our bankruptcy attorney, and he's going to give you a short presentation about bankruptcy and answer any of those questions you might have.
Thank you.
Thank you.
All right, so Nadia and Michelle kind of alluded to some of the benefits. One of the big things that our clients take advantage of is bankruptcy has the ability to stop a foreclosure sale. That's great. There's also a lot of other benefits that bankruptcy can provide to our clients or potential filers. I'll be talking about those and kind of explaining them to you. Before we get to that though, I want to kind of lay the groundwork and go over some kind of preliminary ideas. So these are kind of the individuals that are involved in a person's bankruptcy case. The debtors, these are the people that owe money. These are our clients. These are the people who file for bankruptcy. And here are some of the requirements for who can file. Generally, any individual can file for bankruptcy. Prior bankruptcies don't prevent you from filing a new bankruptcy case. If you're married, you can file a single bankruptcy case with your spouse as a joint petition. And the only other real requirement for filing bankruptcy is that people are required to take a credit counseling course within 180 days prior to filing. credit counseling course is pretty straightforward. It takes about an hour. You can do it online or over the phone. It costs $25, so it's not a barrier to filing bankruptcy at all. Creditors, they're another central party in a bankruptcy. These are the people that debtors owe money to. These are your mortgage lender, car loan company, credit card companies, things like that. Generally, they can be divided into two different classes. Secured creditors, these are people who have a lien on a property, and they have the right to foreclose or repossess that property if you fall behind on your payments. So secured creditors include your mortgage lender, your car loan company. If they have a right to take your home or your car, they're a secured creditor. Unsecured creditors, that's everyone else. They don't have the right to take any of your property if you default or fall behind on your payments, but they do have the right to file a lawsuit against you to collect on your missed payments. Generally unsecured creditors include credit card companies, medical bills, personal loan companies, things like that. The next party to a bankruptcy is the trustee. This person is going to administer your bankruptcy case. They're kind of looking out for the interest of creditors, and they want to make sure that the creditors get as much money in your bankruptcy case as possible, so that's kind of their role. And then finally, the judge. The bankruptcy judge is the boss. They get to decide what all of these other parties can or can't do in the bankruptcy process, and you basically need their approval to take any action or to modify anyone's rights or anything like that. The fundamental idea of bankruptcy is to give debtors a financial fresh start from their debts. The idea is that debtors pay whatever they can to creditors. Sometimes that's nothing at all. And then at the end of the bankruptcy, the debtor receives a discharge of most of their debts, and that means that they don't have to pay them anymore. And so we're going to be explaining some of these concepts in more depth as we go. Another important concept in bankruptcy is the bankruptcy estate. The minute that you file for bankruptcy, it creates a bankruptcy estate. And the bankruptcy estate includes all legal and equitable interests of the debtor and any property that is community property of the debtor and his or her spouse. So basically, this is everything you own gets thrown into the bankruptcy estate. And the idea of the bankruptcy estate is that the value of the property in the bankruptcy estate has to go to your creditors. But before you get panicked about that, you have ways of taking certain assets out of the bankruptcy estate. And you do this by claiming exemptions. Now, exemption laws are kind of complicated. In California, there are two exemption statutes. One kind of, gives a bigger protection to equity in your home that you're living in. The other one, these days not a lot of people have equity, so they generally elect to do the other bankruptcy statute. And just to give you an idea of the exemptions, in California you get about a $23,000 wild card that you can use to exempt any property. You get a $3,500 motor vehicle exemption, and you get kind of miscellaneous exemptions like a $1,400 exemption for jewelry, things like that. But certain categories of your property are fully exempted. So for example, household goods, this includes your furniture, your pets, your CD collection, your clothing. All of that is fully exempted generally. Any pensions, annuities, other kind of tax-favored retirement or savings plans, those are also generally fully exempt. So California has pretty generous exemption laws, and a lot of our clients can fully exempt all of their assets. This means that there's going to be no property or value left in the bankruptcy estate to pay to creditors. So in general, we can get you a pretty good deal. You're not generally going to have to pay a lot to your creditors to get the kind of relief that bankruptcy is going to give you. All right, the automatic stay is a really central idea in bankruptcy, and this is actually what stops a foreclosure sale. The general idea here is that the moment you file for bankruptcy, the court issues an automatic injunction, and that just means that it's going to prevent your creditors from taking all sorts of actions to enforce or collect on their debts. This includes foreclosure sales, includes repossessions, wage garnishments. All of that gets stopped the moment you file. It's automatic. It's an incredibly broad and effective tool. And so here's a little example of the automatic stay in action. The debtor has a foreclosure sale scheduled for 10 o'clock a.m. on Monday, March 1st, 2012. Debtor files for bankruptcy at 9:59 a.m. that same day. Even if the foreclosing creditor doesn't receive notice of the bankruptcy and proceeds with the sale, the foreclosure sale is generally going to be void. That's crazy. I mean, you can file moments before your foreclosure sale, and it's going to protect your home. I mean, that's a sweeping power, and it helps a lot of our clients out because, you know, last minute loan mod denial, what am I going to do about the foreclosure sale? File for bankruptcy, and you know, you can protect your home that way. Now, creditors can ask the court to lift the automatic stay. This just means that they're asking for the court's permission to proceed with a foreclosure sale or repossession or some other action against you or your property, but they have to have cause. And we're going to talk a little bit about the specific chapters in a little bit, but the general rule is that if you're in a Chapter 7, if you're behind on your payments to secured creditors, they're entitled to have the court lift the stay and to go after your property. So in general, it's not going to be a good idea to file for Chapter 7 if you're behind on your mortgage payments, because you're just going to lose your home. It's just going to delay it, you know, for the time that the creditor has to go to court and ask for the stay to be lifted. Now in Chapter 13, the rules are a little bit different. You know, if you're behind on your payments prior to filing, that doesn't really matter. That's going to get repaid through your Chapter 13, as we're going to discuss in a little bit. So really, creditors in a 13 can only ask for the court to lift the stay if you fall behind on your mortgage or car payments after you file. So, you know, that's kind of the general outline. If you file for a 13 and you stay current on your mortgage payments and your plan payments, which we'll be talking about, your home is going to be protected and there's not going to be a foreclosure sale. All right, so let's talk about the specific bankruptcy chapters. Chapter 7 is a liquidation bankruptcy. The general idea, well, it's kind of designed for people who don't have regular income or a way to kind of repay their creditors over a period of time. The general idea is that the trustee has the right to take possession and sell property of the bankruptcy estate, so your non-exempt assets, and they'll sell those assets, and then whatever proceeds they get from the sale, they're going to pay your creditors with that. Like I said, you know, we can usually fully exempt your assets, so a lot of times, you know, a trustee isn't going to sell anything, and you're just going to get a discharge at the end of the Chapter 7. Now, not everyone can file for Chapter 7. There are some requirements. The most important of these is what's referred to as the means test. And you have to pass the means test in order to file for Chapter 7. So what is the means test? It's really complicated. But the basic idea is it looks at your monthly income from all sources, your gross monthly income. So this includes, you know, your paycheck from work, business income, dividends, interest income, rental income, any kind of contributions that you get from family members, that's all going to be income. The one thing it doesn't count is Social Security income. So if you get a Social Security benefit each month, that doesn't count towards the means test. So once you figure out your average income over the past 6 months, that's what's called your current monthly income. And they compare that number to the state's median income for the same household size. And so here are some examples. If you have a household size of 2, you have to make less than $5,129 a month in order to file for Chapter 7. Now, if you don't pass these kind of threshold tests, you get to do a kind of a longer form of the test, and you get to deduct certain expenses from your income. And it's kind of a mixture of your actual expenses, and then certain other expenses are determined by IRS standards for the country or county or state, depending on the category. And if you're if these deductions get you below a certain threshold, then you can file. Otherwise, you can file for Chapter 7. And if you fail the means test, you have to do a Chapter 13. Chapter 7s generally take 5 to 6 months, and at the end of that period, you receive a discharge, which we'll be going into more details later. But before we get to the idea of a discharge, let's talk about Chapter 13. Chapter 13 is a reorganization bankruptcy. So this is designed for people who have regular income and who have the ability to repay some or all of their debts over a period of 3 to 5 years. Generally, debtors pay the value of property in their bankruptcy estate into their reorganization plan rather than having the trustee sell the property in the estate. So, in Chapter 7, you might have to sell some assets. Chapter 13, that's generally not the case. You would just pay more into your monthly reorganization plan. There are certain debt limitations that you can't go beyond in order to do a Chapter 13. For unsecured debt, it's $360,000, and for secured debts, it's a little bit over $1 million. And so the central idea of a Chapter 13 is this repayment plan. And like I said, it's a plan that takes place over 3 to 5 years. If you're above the median income as determined by the means test, it has to be for 5 years. And it kind of looks to your disposable monthly income, what you can afford, and you're trying to put money into the plan to pay off portions of your debt. We'll be talking more about what you have to pay and what you don't have to pay. The big thing about the Chapter 13 plan is that it enables you to change the rights of your creditors. And it's actually kind of surprising how much you can change their rights. So I've broken down some of the categories that we'll be going through. The first one is that debtors can reduce the interest rate and modify the terms for certain secured debts. Now generally, you have to be able to repay whatever debt you're modifying in 5 years. So this is usually going to be car loans. Typically, you can change the interest rate on your mortgage because that's a long-term debt. Basically, you can change whatever the contract interest rate is. You can reduce that down to 4.25%. And a lot of times, that results in a lot of savings for clients. So here's an example based on an actual case that we had. Debtor had a car loan of $2,000 with a contract rate of 99% APR. Wow. The monthly payments were $331.85 paid over 2 years. Filed for bankruptcy, and with the powers of bankruptcy, we were able to reduce the interest rate to 4.25%, which reduced the monthly payment to $39.45 paid over 5 years. Incredible monthly savings there. Another big power that bankruptcy gives you is the ability to reduce the principal balance on certain secured debts. Again, these are going to be kind of shorter term debts, typically car loans, and it allows you to reduce the principal value to the fair market value of the property that secures the obligation. So if you're modifying your car loan, it lets you reduce the principal balance to what your car is worth, and that's all you have to pay. So here's an example. Debtor, again, it's a real example of an actual client. Debtor financed the purchase of an RV with a 12-year secured loan of $53,000 in change at 10.99% APR. Monthly payments were $346.51. At the time of the filing, the RV was only worth $11,000 in change. In bankruptcy, the RV loan principal balance was reduced to the value of the RV, so reduced to that $11,000, and the interest rate was reduced to 4.25%. This reduced the monthly payments to $210.03 paid over 5 years. Again, really good savings. But if you think that's good savings, wait until you hear about this next power. It's crazy. Debtors can eliminate junior liens on property in certain cases. This is called lien stripping. And the requirements are as follows. if the debtor's first mortgage is underwater, meaning that they owe more on their first mortgage than their home is worth, any junior liens, like home equity lines of credit, second mortgages, whatever you want to call them, those can be eliminated entirely in bankruptcy. And so here's an example of that. Debtor has a first mortgage of $300,000 and a second mortgage of $90,000. Her home is only worth $250,000. In this case, the debtor can eliminate that entire second lien, $90,000, if they complete their Chapter 13 bankruptcy. Crazy savings. The one hitch is that you have to get through the entire Chapter 13 plan. You have to stick it through that 3 to 5 year period in order to get rid of the lien. If your case is dismissed or converted, that lien is going to stay on the property. And so you only get this sort of relief if you can make it through the entire plan. But it's crazy. I mean, in this example, it's $90,000 of savings. Sometimes we see even higher savings. All right, another really important power of bankruptcy, Chapter 13 specifically, is that you can pay off arrearages on secured debts over the course of your plan. Arrearages is just the total amount of your missed payments, your late fees, penalties, foreclosure costs. These sorts of things are all called arrearages. And like I said, you can pay those off over the course of up to 5 years in bankruptcy. And like I was saying earlier, the automatic stay can only be lifted if you fall behind on your payments after you file for bankruptcy. And so here's an example of this in action. A debtor pays $2,000 each month on her mortgage. She missed 6 payments, which together with late fees, penalties, and other costs, brings her total arrearages to $16,000. The debtor files for Chapter 13, and while in bankruptcy, she still has to make those $2,000 monthly mortgage payments each month, but her arrearages get to be paid through the plan. So in this case, if the debtor doesn't have any other debts that have to go into the plan, and she has a 5-year plan, her monthly Chapter 13 plan payments are going to be around $300. So basically, to save her home, she has to pay $2,300 a month while in bankruptcy. And so long as she makes her ongoing mortgage payment and her plan payment, her home is going to be protected. Okay, so what do you have to include in your bankruptcy plan? Well, as we already mentioned, arrearages on secured debts that you want to repay have to be included in the plan. Any attorney's fees that you don't pay prior to filing get thrown into the plan. Priority debts, this includes recent taxes, so generally taxes that have been incurred within the last 3 years have to get paid off in the plan. The older taxes get discharged at the end of that. And domestic support obligations, child support, alimony, those have to get paid into the plan. If the plan alters the rights of secured debt holders, like we talked about, either reducing the interest rate or the principal, those debts have to get repaid through the plan. And Chapter 13 has a means test just like Chapter 7, but in Chapter 13, if the means test shows some disposable monthly income, you're required to pay that to your unsecured creditors each month during the course of your bankruptcy. The final thing that gets thrown into the plan is the trustee's fee. So they get a commission basically for administering your bankruptcy estate. And generally it's around 10% of everything that you pay into your plan. And so here's an example of calculating a debtor's bankruptcy plan. So this debtor has ongoing mortgage expenses of $2,000, arrearages of $16,000. She also has priority tax debts of $5,000 and unpaid attorney's fees of $2,500. The arrearages, tax debts, attorney's fees must all be paid into the plan, so that totals $23,500. Trustee gets a 10% commission, which brings the total to $25,850. So with a 5-year plan, her monthly payment's going to be $430 or so. And again, she still has to pay that ongoing mortgage expense of $2,000 every month. So That's kind of the cost and how you calculate it or get an idea of what you have to pay each month to stay in Chapter 13. We'll just skip that. There are other chapters of bankruptcy. Generally, they don't apply to kind of individual debtors. They're more for municipalities or businesses. All right, so let's talk about the discharge. Now, this is kind of the point of a bankruptcy. This is, it's huge. It's going to get rid of all your dischargeable debts. In a Chapter 13 case, you get a discharge at the end of your Chapter 13 plan. So after that 3 to 5 year period, you get that discharge. And in a Chapter 7, you get a discharge at the end of your case. So that's typically 5 to 6 months. And in both Chapter 7 and 13, you have to complete a course in personal financial management before you can receive a discharge. This is basically the same as that credit counseling course. It takes about an hour. You can do it over the phone or online. And generally, it costs around $35 for this course. So what's dischargeable? Most unsecured debts. Your credit cards, gone. Medical bills, gone. Personal loans, gone. What can be discharged? Well, like we were talking about, certain taxes, generally if you incurred them within the past 3 years. Domestic support obligations, you can't get rid of those. Most student loans aren't dischargeable, I wish. Most criminal fines and restitution obligations, can't get rid of those. There's kind of a whole slew of these debts that arise from misconduct. You generally can't get rid of those. That includes fraud, theft, driving while intoxicated. Generally, those are going to stick with you. Long-term secured obligations, like mortgages, you're not going to discharge those, or you still have to pay those after your bankruptcy if you want to keep your property. So, a discharge isn't going to get rid of your mortgage payments. And Chapter 7 has a few additional categories of non-dischargeable debts, but nothing really, very common or applicable. All right, so there are also a few limitations on who can receive a discharge. And just the general rule of thumb is that if you received a discharge, sort of recently in a prior bankruptcy, you can't get a new discharge in your new case. And again, it's not going to prevent you from filing. You can file another bankruptcy even if you had an old one. That's not a problem. But you're not going to get a discharge if it falls under one of these categories. So just very briefly, if you received a discharge, under Chapter 7, if you received a discharge in a prior Chapter 7 case within the last 8 years, no discharge in your new one, your new Chapter 7. If you received a discharge in a prior 13 case within the last 6 years, generally you're not going to receive a discharge in your new Chapter 7. If you are filing for Chapter 13, you can't get a discharge if you received a discharge in a prior Chapter 7 within the last 4 years. And you can't receive a discharge if you received a discharge in a prior 13 within the last 2 years. So, generally it's a little bit more forgiving with a Chapter 13 as to whether you can receive a discharge. But those are basically the only limitations on getting a discharge. So, most people are entitled to a discharge. And so, that's the end of the bankruptcy presentation. I know it's a lot to throw at you. And so if you have any questions on bankruptcy or loan modification, please let us know and we'll try to answer them. No questions? We covered it all.
Actually, I have a question regarding debt settlement. What's the difference between bankruptcy and debt settlement?
So, yeah, that's a good question, and we get asked that a lot. Generally, I think that a bankruptcy is going to be a better option. One of the consequences of doing a debt settlement obligation, or just a debt settlement, is that you get taxed on whatever reduction in principal there is. So let's say they forgive $5,000 of your debt. That's going to count as income for your next taxes. And so, that can have a pretty big consequence, especially if you're getting a lot of principal forgiven. Bankruptcy, if you discharge those debts in bankruptcy, there's no tax consequences to that. So just a general rule of thumb, bankruptcy is going to be a better choice because you're going to avoid those tax consequences.
Also with debt settlement, it's a voluntary negotiation with the creditor. They're not obligated to settle your debt. it could take 3 years, 4 years, 5 years where you're paying a debt settlement company a monthly payment with no promise whether or not you're going to actually be able to settle that debt at the end of the 2 or 3 or 4 years. Meanwhile, they're taking their fees, which might be 15, 20, 25, 30% of what you're paying. I would say 9 out of 10 debt settlement companies that we've seen or dealt with or heard about are doing bad business. I would recommend staying away from debt settlement.
Yeah, I heard that you can get lawsuits from creditors as well.
Exactly. Creditors, meanwhile, can start suing you, garnishing your wages, levying your bank accounts. So it's usually not the way to go.
This is a question for Joy, if she's here.
Right here.
I'm Howard Greenberg. I'm the Cal HFA official. I brought in a package here. If you can look over briefly, hopefully we can sign up tonight. But anyways, on the Cal FHA worksheet expenses, there's a spot where they say list savings. Now, is that a hoop to jump through, or?
Because the reason what happens with these banks, when you're filling out like the hardship package, they want to know what money you have set aside. Because if you tell them that you have, let's just say 50, I think yours is like, let's just say $20,000, that's in your account, your savings that you've been saving up for a day or something, just in case of emergency. What happens when clients release too much information to the bank sees those savings account, IRA, pension, whatever, it's just they see money. They
Right.
see if you're behind, they'll be like, hey, Howard, you know, you got that money, why don't you just pull that out and pay me? Keep you current. The whole bank's goal is to keep you at a higher payment versus lowering your payment. And I think your case was that they found out about that money, which they're trying to use it against you to get you modification.
Because I listed on the first
Right,
denial.
correct, and that's what these banks would do. The more money that you show, they can just say, hey, we'll deny you, withdraw your money out of 401k, withdraw your money out of pension, withdraw your money out of savings. They're basically there to hang you guys dry.
Well,
But in your case, it can, you know, I think yours was like, I think it was just recently denied, right, Howard? I don't know.
in November, I even got the letter.
Right.
I guess I'll put it this way. Legally, can I get around that? Because they do ask for it in one box on the expense form.
I know we can elaborate on that. Your lender is only aware of the information that we tell them, that we give them. If we don't tell them about it, they're not gonna know. Typically, they're not gonna know unless it's apparent on your bank statements. We can say, for example, if it's blatantly there on your bank statements that we have to submit to them, that's one of the things we do in the preparation when we do that introduction. When we're reviewing your file, me and Nadia are going to see that you have $20,000 in savings. We're gonna give you the red flag heads up of, hey, if your lender sees that, they're not gonna like it. So you might wanna move it into another account, move it aside, so when we do submit your bank statements, your lender doesn't see it. It's not something that's illegal, we're just trying to prevent, you know, having to jump over those hurdles later. But your lender's only aware of the information that we tell them. We're not lying to them or anything. We just don't want to have to worry about that affecting you later.
It's kind of a omission, and that's the main hoop. Whether I like to go with you guys tonight, but if that hoop can't be overcome, then I got to think about it all.
It absolutely. We're successful. You know,
Yeah.
It's just a way to help you get that modification.
We can advise you what will help your chances and what will hurt your chances. It's ultimately going to be up to you whether or not you want to take different steps so that you don't have certain assets under your name, certain accounts or cash in an account under your name. If you want to take those steps, put yourself in a better position, we'd be happy to at that point, you know, submit you, but it's ultimately going to be up to you.
Yeah, the bottom line is it's not ethical. I'm not looking for ethical or persuasion with them anymore. I just want to know if it's legal. That's all I want to know.
If you're omitting an asset that you have and you're writing on a statement that you don't have that asset, it's under your name, I would say that, you know, potentially you're misrepresenting what you own. What we normally suggest is we say, get your family members involved. If it's an asset that you can transfer to a family member, then by all means do that. That's not illegal. By all means, you can always transfer whatever assets you want to family members, friends, or whoever else you can trust. And then at the time of filing or completing the application, you don't have it anymore under your name or in your accounts.
So that means that basically I would have to give any savings I have to somebody else right now, right?
It's like putting it in your wife's bank account. Like we said, if your wife or if your daughter has an account that she would allow you to use, you could just transfer it over to her account.
And I think we can talk more about your specific case a little bit later on.
I don't know, also last question quickly. The banks or the government, they're not by law obligated to give you a loan, are they?
That's correct. They're not obligated to you. They have certain obligations that they have with the Treasury Department. Recently, with the settlement that I don't know most of you probably are aware of, now they have obligations to the state attorney generals who signed on to that settlement. However, they don't have a personal obligation, or they don't have a direct obligation to the homeowners, the borrowers. So this could be something where the California Attorney General could get involved and say, hey, Wells Fargo, 2,000 of your current borrowers right now are complaining to me saying that you didn't provide a modification in a situation where they should have been modified. They qualified under the guidelines. That's how. So there's no personal obligation, or there's no direct responsibility to the homeowner.
Okay, thank you.
Any other questions?
And we have lots of snacks, and we're going to be around to ask any other questions. If you have any personal questions or just want to meet the staff, we're here if you want to hang out.
Very good.
Thank you.
Pretty good.
Yeah, so that's as how much second question, is there issues?
The last name. Eric Raspberry. Shelby. Pleasure to speak with you, Mr. Raspberry. Actually, we don't really share information about specific clients and everything. We're very, very big on confidentiality at our law firm. Sure. But I know chop it up and go back and forth with each other.
So there are kind of default permissions. Either way, it's just pretty
I called I think it was more answered. He's like, what do you want? I'm like, let's talk about your daughter. He's like, oh, I asked my daughter. This is when I call my dad asking for money too. Pretty much. She's like, oh, Michelle's calling. What do you want?
That's for sure.
But it's a pleasure to actually meet this person. Thank you for coming in. Do you have any questions I can answer? Your file? Oh, that's a talent.
So now, in a 13,
I know. That's why you tried to like.